have not been read over to your lordships till date is an eye-opener. But I have got 4 points. I will come to that after the dates are.
Just start. Give us the dates.
Yes. Then this notification comes on 30/9/2015.
Asking the scheme of examination is a part of the rule.
The scheme of examination is an administrative notification or it's a part of the rule?
It's an administrative full court.
It's a full court resolution, I think.
Minutes.
We'll just go to that. That is, we have not seen that yet.
Exactly.
Now, 30th September 2015 is the High Court notification.
The written test was conducted on 12/3/2016 and 13/3/2016. The notification regarding candidates qualified in the written test came out on 17/12/2016. The Viva-OC was conducted from 16/1/2016.
17.
17.
17 to 24/1/2017.
17.
1617.
January 2007. 17 to 24/1/27.
The minutes of the Administrative Committee is dated 27/2/2017. Which was approved by the full court on 6/3/2017. The final list came on 6/3/2017 on the same day. Now I have got 4 points. I will not take more than 10 minutes.
Just
Hold on 1 second. Should we finish with finish now? Of appointment issued?
I have been working
because there are no entry model.
from
So those will continue.
2017.
So pretty much, I think they must have been appointed by the governor after the consultation with the governor consults the High Court.
2017, as per the final list, those were appointed and they are continuing in service.
1 year service in the 1 year training in the Judicial Academy in first year. Then they are posted.
You can't disturb the posting.
So now you are, and your clients are out all these years.
Out all these years.
Now those people are already in since 2017.
I scored high in the written test.
Now, Mr. Chidambaresh, the only problem,
6 years.
6 years, these chaps have been working now in the district judges, as in the judiciary, right? These are recruitment to civil judge, junior division.
Milord,
District judge.
my anxiety is only
This
this.
is a lateral entry to the district judges.
I know it will be difficult to displace them now. I know. But the problem is this. One among the petitioners is doing exceptionally well at the bar. Milord, her chances of being elevated to the bench will be affected because the allegation is you did not pass the district judge selection.
is, prima facie, what is, of course, we'll hear the High Court lawyer. Who's appearing for the Kerala High Court? Jose, no?
Naidu, who said he wants to.
Sheshadri is appearing. Oh, yes. All right, no problem.
You can ask.
Now, Mr. Chidambaresh, assuming that you are right, this issue of change of the rules midway, strictly speaking, is a subsidiary issue. Yes, they did change the rules midway because it was after the Viva Voce was conducted that they introduced this minimum cutoff for the Viva as in terms similar as the written exam. But more important in this case is the fact that the minimum cutoff which they imposed for the Viva was directly contrary to the Rule 2C3.
Scheme of examination also stipulates that.
Now,
Kindly,
Mr. Chidambaresh, having said that, we just look at the scheme of examination in a minute. So, really speaking, the reference may not arise in this matter. Two, if you are right, subject to hearing Sheshadri, if you are right, the decision of the High Court to introduce a minimum cutoff was contrary to Rule 2C3. But third, coming to the grant of relief, at the end of 6 years now, when these people are working, we may not be inclined to disturb those who are already working. What we could do is this. We will say that many of your clients would have now joined the bar. Probably all of 4 of them have joined the bar. If they are good, they may even aspire to becoming High Court judges in future. We will clarify that our decision not to grant you relief has no bearing on your intrinsic merits. And therefore, the fact that you did not ultimately qualify in this examination will not affect your future prospects in any other selection.
exactly. That is my apprehension also.
For all we know, any of you may become High Court judges tomorrow.
Hopefully.
Yes, we've had High Court district judges who resigned, joined the bar, and then became High Court judges.
Yes.
How many in this batch of 4 matters? No, there are only how many petitioners are there?
10.
They are here before us. But everybody is served.
My lords, in fact, in 215, although it appears for the Gujarat High
Just one
Court,
second. But the fact that R9, 11 and 12 would have ranked below you in the aggregate marks, that's what you're saying, much below. But the fact still remains that now they've been working as district judges for the last 7 years. Many of them would be now virtually coming on the threshold of becoming High Court judges,
Whereas you would have joined the bar or seen something else. Because 6 years wouldn't have gone by without.
All right, look at it from your point of view. Suppose we appoint you as district judges today, or we say that you should be appointed. We can't give you seniority of 2017. Your seniority will come today. But I know they are okay because today this is such a valuable employment under the state. But the point is that, now to displace people who are working, after all, they've worked as district judges for...
There's another issue, there is a human problem involved, my lords. 6 years they are expecting, and the practice also,
We understand that.
my lords, side by side.
Dinesh, you're absolutely right. No doubt about it.
Just for any lawyers.
We are completely with you on that. But, now we have to look at both sides, You have on the other hand, people who are working as district judges for 6 years now to tell them you go home. And after working you tell me to join the bar today, I don't know what will happen to me, because if I don't think I can answer questions of judges as Brother Narasimha was answering until recently.
Narasimha is the only exception.
How will these people even go back to the bar after having been judges for 7 years? It's very difficult to go back to the bar and start a new career,
If it were a selection which is arising immediately thereafter, perhaps we would have asked the High Court to give them some kind of a concession or relaxation and take them in. But then this period of 6 years is something we can't tell the High Court to, in the next selection, give a priority or some kind of.
6 years is too long.
Oh, but then after 60 years.
Yeah, that would be an unfair thing to accommodate them now. You lose seniority in so many things. I mean, in service. You see, I was just telling Honorable Chief Justice, for all you know, this decision of the administrative committee might facilitate those who are in practice to come into the bench of the High Court faster than these people who have been selected as district judge. Possible. No, one is just saying, I mean, to upset those who are already working.
Mr. Nataraj?